Hi, I'm Lisa Johnson, and I'm head of investment law and policy at CCSI, and I did the presentation on international law and implications for governance of extractive industries. I received a few questions that were relevant for my presentation, so I just wanted to briefly go over some of those. So thank you very much for your questions. The first question that I got was, in the event of non-compliance in the field of oil and gas production, are citizens that are in areas affected by poisoned gases and waste oil able to sue those companies in international courts and to redress environmental damage? That's a great question. Now, in my presentation, I focus on international investment treaties, and notably, those treaties don't permit claims by citizens against companies for environmental or other harms. Rather, they only allow claims by companies against states. So at present, there really aren't any international courts that are set up to hear claims by individuals against companies. But I'll briefly survey some of the international and domestic avenues that can be pursued. International human rights courts, such as the Inter-American Court of Human Rights, and those can hear claims by individuals against states for actions and omissions by states with respect to impacts of extractive industry projects. But those are claims, again, by individuals against states. They can't be against companies per se. Now, there are also international mechanisms like the OECD's National Contact Point Mechanism, which is used to enforce compliance with the OECD's guidelines on multinational enterprises. But the NCPs, the National Contact Points, those have limited sanctioning enforcement and enforcement power. So they're really more of a soft law instrument than a body created by a treaty or an actual court. In terms of other mechanisms, citizens can try and bring claims against multinational enterprises in their host country, the host country where the harm was caused. But there may be limits to that. For one, including that the entity that's incorporated locally might not have sufficient assets in the host country to satisfy a judgment. Alternatively, citizens can try and bring claims against multinational enterprises in the home country, in the investor's home state. The rules on the separateness of corporate entities, the separate legal personality of parents and affiliate companies, for example, and doctrines in companies' home states may limit home states' courts' willingness or ability to hear claims relating to harms that occurred overseas. Now, so that said, there's some efforts to address these challenges in securing recourse against harm caused by multinational enterprises. So these include what's ongoing now. There are discussions related with respect to human rights. Additionally, the Southern African Development Community has a model bilateral investment treaty template provisions that would, among other things, require home states to ensure that citizens from the host state have access to the home state's courts, bring claims against the home state's multinational enterprises. So those are some ways that international law can be used in order to provide recourse to citizens, for citizens that recourse doesn't currently exist. So a second question that I had in relation to my presentation was, how can states apply international investment law in facilitating doing business in their countries? Now, one theory behind international investment treaties is that when a state signs the treaty, it's sending a signal to international investors that it's a good place to invest, that it has a safe investment climate, and that it's open to foreign investment and really looking for that foreign investment to come. So the data, however, on whether or not treaties are actually effective at sending those signals is mixed. So we're not sure that investors are getting those signals, or whether the signals actually matter to investors, the signals sent by investment treaties. Now, if a state wants to facilitate and encourage international investment, it can do so entirely through domestic measures. It doesn't need to sign an international investment treaty. This includes by taking steps to improve its fundamentals, investing in necessary infrastructure and education, improving domestic rule of law by tackling corruption and improving the quality of its courts, and clarifying the rules regarding permitting decisions and the legal frameworks governing the projects. So those are things that a government can do irrespective of signing an investment treaty in order to improve its investment climate to attract investment. Now, a third question that I received was, why do we continue with international goals such as the Sustainable Development Goals that were recently adopted and that are to govern, to really guide conduct on achieving sustainable development over the next 15 years? The question is there a legal base within the UN to do this, or is it a combined effort of responsible parties? So the SDGs, they're intended to be universally applicable, but they're not a negotiated treaty. So therefore, the SDGs function somewhat as a form of soft law. They themselves aren't embodied in a legal instrument with teeth for enforcement, but they're still grounded in and can be used to help drive progress on other international legal instruments that are binding. So these include human rights treaties and environmental treaties. Progress on the SDGs ultimately necessitates national action and gives each country latitude to shape its strategies for progress on these goals. So they are designed and shaped through the UN process, but will depend on this action at the national level in order to ensure their implementation. I think those are the three questions that were relevant for my presentation, but thank you very much for your time and for your questions. I hope I answered them. All right, thanks. Bye.